Now coming to the soul of the arbitral proceedings, which is Indian Contract Act 1872. To begin with, Indian Contract Act 1872, first we have to understand what is the formation of contract. Section 7 deals with formation of contract and says that acceptance of the contract must be absolute and unconditional. This is very important because when we issue the acceptance letter on behalf of President of India, we accept such and such tender. But if there is any clause in that acceptance such that subject to the performance guarantee 5% or 3% to be submitted, then that letter cannot be said to be forming the official forming of the contract. Contract does not come into force with respect to that letter because it is not absolute and it is not unconditional. Acceptance has to be absolute and unconditional. So when does the contract comes into action? It is only when the work order is placed. Unless the work order is not placed, contract does not come into force. And this is very important because in recent arbitration case, there was claim put forward by the contractor where he had given about 7.5% of rebate during the negotiation stage of FH items, and it was prior to the acceptance issued or the work order placed. And when he went into the arbitration, he was asking for the reimbursement of that 7.5% of rebate. Now this claim is not admissible. It is not admissible because it is predating the existing of contract. Contract has not come into the force, and if the contract has not come into the force, condition 70 or any other condition of 2249 has not come into force. So such kind of negotiations or anything which is predating the existence of contract cannot become the part of claim since the contract has not come into force. Now again, a very contentious issue in the working of MES is the application of PMG, Project Management Group. Now section 37 talks about doctrine of privity of parties. Our ENC branch in time to time floats the roles and responsibilities of PMG, and very importantly they restrict the role of PMG. It is very correct because section 37 says the obligation of the parties to perform the contract. No third party can enjoy the fruits or benefits coming out of the contract agreement which is not the party to the contract, and third party cannot impose their obligations, their rights or their decisions upon the contract agreement. So we need to be aware of our rights and obligations under section 37 of Indian Contract Act. So PMG has to be kept away as far as the important decisions are to be made in view of the contract agreement. Coming to another very contentious debatable topic is time being the essence of contract. Recently the jurisprudence in India has evolved very dramatically, and there is a very hot debate going on when to understand that time is the essence of contract and when not to understand that time is essence of the contract. Time being essence of contract is covered under section 55 of Indian Contract Act 1872. It talks about two situations. Number one situation is when time is the essence of the contract. If time is the essence of contract really and one party fails to perform its obligation under the contract within the stipulated time, then the innocent party has full right to rescind the contract, to cancel the contract. The contract becomes voidable at the option of promisee, as it says in Indian Contract Act. And in such a scenario, we have full liberty to impose liquidated damages, which in our case is covered as 10% of contract agreement amount. So if time is essence, then if the date is missed, we have the full liberty to cancel the contract and impose liquidated damages, and there will be no issue. However, the second situation, if time is not the essence, if time is really not the essence, then in such a situation, if we have accepted the performance of the contract beyond the date stipulated, then in such a scenario we cannot impose liquidated damages, but we can only impose the actual losses occurred to the Union of India or to another party, and in such cases the contract does not become voidable at the option of promisee and the party cannot rescind the contract. Now, how to differentiate that when time is essence and when time is not the essence? So, there have been quite a lot of judgments by Supreme Court of India and other high courts. A very recent judgment called Welspun Society versus ONGC, decided by Honorable Supreme Court of India in November 2021, it says that if there is a clause of extension in the contract and liquidated damages of 10% CA, then time cannot be said as the essence of the contract. So, that is how Supreme Court has identified that time will not be treated as the essence if there is a clause of extension and there is a clause of 10% of compensation of CA. However, this decision of Supreme Court is hotly debated, and if it is truly implemented in letter and spirit, then it will lead to complete catastrophe and the collapse of the standard form of contract which we implement in MES Pan India. Because we have to accept that there could be grounds where there is no fault of both the parties, neither the department nor the contractor. Let's say COVID, let's say there is a flood. So, in such a situation we have to provide extension. There is no reason not to provide, and if there is no clause in the contract to provide the extension, then we will be finding ourselves in a tough situation. So, we have to put the clause for the extension for the cases where the delay has happened, where there is no fault of both the parties. In nutshell, if I summarize the entire debate on the time being the essence of the contract, what is the solution? Where do we actually stand? So, my request would be, number one, that we have to identify that the extension or EOT which we say, if we are giving to the contractor, we have to understand that the delay should not be attributable to either of the parties, neither the Union of India nor the contractor. It should lie somewhere else on the third party or the natural reasons, number one. Number two, if the ground of delay is being given extension, then it has to fall on the critical path. It should lead to the delay of the actual completion date. If it is not, then EOT will not stand the scrutiny of the law. Third is that we have to prove, we have to show, we have to inform the contractor or the other party that if the obligations are not met within the stipulated time or the performance is not met, then Union of India will incur such and such loss. This is important. This is called legal injury. We have to show and we have to prove the legal injury. We may not be able to prove the actual losses, but actually we have to show the legal injury in order to avail the benefit of imposing the liquidated damages in form of 10% of CA. Now, how can we show? For example, if I explain here that if we are making some married accommodation, then we can say that if the married accommodation project is not completed within the stipulated time, then beyond the date, Union of India will have to incur the additional losses in form of the HRA being given to the officers or the families living outside. Similarly, let's say you have a contract of furniture. So, rent calculated against the furniture which we charge from the users, if that is the contract is not completed within the stipulated time, then the delay will lead to the recovery, the cost of the furniture, that when the cost is not getting recovered, it is lost to state. So, we have to prove, we have to show, we have to inform the contractor before the completion, and we have to tell them that if this work is not completed within the stipulated time, then such an loss shall be levied upon the contractor. So, these are three basic steps which have to be followed in order to impose the liquidated damages or any other kind of damages. Coming to a very important concept of doctrine of frustration. What is the doctrine of frustration? This is covered under section 56. It says when the contract becomes impossible to perform. Now, what does it mean? For example, let's say 85% or 90% of the work is balanced and only 2 to 3% of the time is left, and the delay is attributable to the contractor. In such a scenario, we all understand, we all know, it is common logic, human logic, that balance quantum of work of 85-90% cannot be completed in 5 to 10% of available time frame. If such a situation arises where you can conclude that work cannot be completed and it is becoming impossible to complete the contract, then you can invoke doctrine of frustration and you can rescind the contract. You can cancel the contract even before the completion date. This is called invoking doctrine of frustration, but it has to be invoked very judiciously and in a timely manner. The next topic, the very important topic, is what is breach of contract. Often during the arbitral proceedings, breach of contract is cited by the contractor that department has not done this, department has not done that, and it has led to breach of contract. What is breach? Breach is defined in section 73 of Indian Contract Act. The meaning of breach says that the act of one party should be in some form that it goes to the roots of the contract, it goes to the fundamentals of the contract, it destroys the roots and the fundamentals of the contract, and it makes the performance of the contract either very, very difficult or nearly impossible. If the act is such in nature, then only it is breach. For example, you have a building where the type of footing is isolated footing. The footings are casted about 70-80%, and now there is a change in drawing and you come up with new drawing of foundation as pile foundation, and you ask contractor to complete the work within that cost, within that time. Now this is breach. The act of the party has destroyed the fundamental of the contract. It has led the performance of the contract impossible or very, very difficult. Only then such acts are treated to be breach. It is not that gate pass is not issued or the material is not available or the department has not given the design on time, drawing on time, it is breach. No, it is not breach. Breach is a very, very narrowly described concept and very strictly enforced. The most important topic of Indian Contract Act is damages. Damages are generally of three types. One is general damage, one is special damage, and third is liquidated damages or pre-estimated damage. The first, I would begin with liquidated damage or the pre-estimated damage. Liquidated damage or estimated damages are those damages or the compensation. I would use both the terms interchangeably. Damages or compensation in the liquidated damages form or the pre-estimated are those which are predefined in the contract, which have been mutually agreed by the parties. In our case, it is the 10% of CA, and it is only applicable in the breach of timelines, not the breach of technical or any other issue. So this is liquidated damages. Second is general damage. General damage is which is arising out of the natural course or natural flow of the performance of contract. For example, if a contractor has taken a contract and the work is not completed on time, so there is a loss of overheads upon the TNP machinery equipments which is put there, and there is a loss in the profits. So this is a general loss, general damages. This is arising naturally out of the performance of the contract. This is a natural outcome. So there is no special logic or the reason which can be applied. This is a general damage. Third is special damage. Special damage is sometimes also called remote damage. Remote damages and special damages are generally not entertained and generally not applicable. For example, if a contractor says that because of the prolongation in one of the tender or the contract ongoing, he is not able to bid in some another contract. So he has lost the opportunity to bid in some other contract. This is a special damage. If he is asking any claim or any amount of money with respect to this, this is a special damage. This is not applicable. Special damages are applicable only when there is a contemporaneous record. The contractor has well within the time informed the Union of India, or the Union of India has informed the contractor, vice versa, whatever it is, that if the performance of contract is not met, then such a such damage would appear or such a such damage would happen. Unless there is no knowledge, unless it is not entertained, unless it is not acknowledged, generally the tendency is that the special damages are not entertained. They are very, very remotely applied. Last but not the least is the penalty. Penalty, for example, where it acts as a deterrent. Indian Contract Act Section 74 strictly prohibits the application of penalty. For example, in present contracts, day-to-day maintenance, for example, if we put, let's say, a penalty of 5,000 rupees if certain complaint is not addressed within 1 day or 24 hours, then this 5,000 rupees, let's say the complaint is of a bib tap, this becomes a penalty. Why it becomes a penalty? I'll come into the discussion. So penalty is not entertained. In summary, how to establish the claims or the damages? The first step is to establish the breach. Where is the breach? As I said, breach has to go into the fundamentals and the roots of the contract and has to make the performance of contract either impossible or very, very difficult. Unless it is not so, it is not a breach. So first, the party, whether it is Union of India or the contractor, has to establish a breach of the contract before it starts arguing upon the claims. First step is establish the breach. Now second step is the duty to mitigate. Section 73 of Indian Contract Act says that the innocent party also has an equal responsibility like the defaulting party to mitigate the losses, mitigate the damages. The innocent party cannot sit keeping hand in hand, or it cannot sleep while the damages were happening and later on stand up and say that I want such a such claim. No, it has to show that what steps did it took to minimize the losses. Even though there was a fault by Union of India or by the contractor, whatever it is, the other party, the innocent party, has to show that they have taken such a such step, but despite those steps, they could not mitigate the losses, they could not mitigate the damages. So first is to establish the breach. Second is to establish the steps they have taken to mitigate the losses, to mitigate the damages. While awarding the damages or compensation by the arbitration tribunal to the party, innocent party, they have to keep this in mind, that what steps have been taken by the innocent party to mitigate the losses. If they have not taken any steps, then it would be difficult to claim the damages. These issues have to be factored in, and it becomes our responsibility as Union of India while defending the cases that you have to establish that the party in front has taken or has not taken any step to mitigate that losses. For example, let's say excavation in hard rock. If the contractor says that he has encountered hard rock, however, a BOQ item says excavation in soft soil or hard soil, but they have encountered hard rock and there is a dispute between to establish whether it is a hard rock or it is a loose soil, whatever it is. So they cannot come after 1 year and say that because of the hard rock encountered, they have incurred so much of loss while excavation. They have to prove that they have done sufficient test. They have called some neutral party, third party, to examine that exactly the type of strata encountered is actually the hard rock. If they have not taken any such step, they cannot come later on asking for the claim for the damages done by one party. The most important principle while awarding the damages or the compensation is the doctrine of compensatory damages in nature. What is compensatory in nature? It means that when the arbitral tribunal is awarding any damages or compensation with respect to any claim, then they have to assume that if the contract would have been performed in its natural course of action or in the ideal scenario, how the party would have got benefited. It is not open to the whims and fancies of the arbitral tribunal to award anything. They have to understand that if the contract would have been performed in its natural course in the ideal manner, then what benefits would have accrued to the innocent party. So the damages or the claims or the compensation awarded should be reasonable in nature. There is a doctrine called doctrine of unjust enrichment. It cannot happen that there is a damage or there is a issue with respect to 1 rupee and the contractor is asking 100 rupees or 1000 rupees. He cannot make merry out of that claim. It is called doctrine of unjust enrichment. So the arbitral tribunal has to be very careful while awarding any claims, damages or compensation, that the damages, the claims have to be reasonable and they have to be compensatory in nature. The last and the most contentious topic is the liquidated damages. As I said, during the time being the essence of the contract under section 55, the jurisprudence upon liquidated damages in India has evolved since 1963. There was a case, Kailashnath versus Balkishan, 1963. Then in 1969, Maula Baksh versus Union of India, and the recent 2006 judgment, ONGC versus Saw Pipes. The nutshell is that present scenario, it is very difficult if you have given the extension of time once or twice, and then if the work is not completed after the extension is given, and then you apply liquidated damages or 10% of CA. It becomes very difficult. To overcome such scenario in the present circumstances, in the present jurisprudence of India, you have to prove at least the legal injury. If not the actual losses incurred, at least you have to show that there is a legal injury to the party, where if the contract was not performed within the stipulated time frame, it has led to certain losses and there is a legal injury. It is not important as per section 74 to go into the details of the losses and to calculate everything, but it is important as per the jurisprudence what has evolved that the legal injury must be shown. And the recent case what I discussed is Welspun Society versus ONGC, Supreme Court of India, decided in November 2021, where it says that if there is a extension clause in the contract and there is a liquidated damages clause in the contract, then time is not the essence of contract. So the issue is still evolving, but my stand would be that at least as of now we need to prove the legal injury which has happened if the contract is not performed within the stipulated time frame, so that there is no contention with respect to from contractor when 10% of CA is levied upon the contractor as liquidated damages. And as I said, penalty is absolutely not applicable in the Indian scenario. It is prohibited by Indian Contract Act.